I think it's all three. I don't think app-based gig workers can pass any of them. It's always the B prong, but A is you're free and clear from the hiring entity. I mean, no, you're not. I mean, you can be, but they tell you which route to take. They tell you where to go, what time you have to be there. They penalize you with these fake scores and stats. And, oh, you're a platinum tier now because you take 80% of the acceptance rate isn't a thing for independent contractors. Your performance is a thing between you and your contractor. I know a person who was audited in Oregon as a rideshare driver, and the state auditor asked them for all 7,000 rides that they did that year. And they said, ask Uber. I don't have them. And they said, you're the contractor. That's on you. He actually got fined heavily.
The individual. In what state was that?
Oregon.
Oh, okay.
So, I mean, my point is like,
Blue state.
We don't have, I can't, if somebody came to me and said, show me all the gigs you did last year, I can't. I mean, I could go through a bunch, but I can't. I
don't even think I could tell you all the articles I wrote. I could go back and look at invoices, I guess, but I couldn't remember if you asked me.
I think if you're a gig driver doing 25 rides a day of people you don't even know that are just being passed along by a dispatch algorithm. I mean, my question was, why aren't you just asking Uber? You know where the information is. You really want it. Go get it.
What's different about prong A is what you're talking about is prong A of this ABC test.
Yeah.
What I read, what I have on my screen in front of me, I'm going to read it directly. This is a top labor attorney, Richard Reibstein, here in the state. He wrote, one of the most objectionable provisions dealing with prong A, requiring compliance with applicable laws. He says the proposed regulation pertaining to prong A departs in a dramatic manner from virtually every other test for independent contractor status under federal law and the laws in every state. Because what he writes is the services that almost all independent contractors provide are typically governed by a number of laws. Mm-hmm. But the regulation, as he writes, seems to regard a commonplace requirement found in almost every independent contractor agreement, a clause requiring the contractor to comply with all applicable laws as a form of direction and control. Yeah, go ahead, Mike.
That is a completely false statement, although the attorney is dead right in his assessment of it. That is to saying that you've got to wear, a safety helmet on a construction project does not make that a direction and control for how to do the work. So the state regulation proposal.
No, that's a PPE requirement for anybody to go within the.
I think about it. I'm a freelance writer. I don't know that I've signed a contract in 20 years that didn't have a clause about libel law saying you hereby promise you're not going to libel anybody.
Right, and that the libel law is that is included in the direction and control prohibition. What the new prong A will do is drive any intelligent, counsel advised client away from independent contracting. And these guys know it, because I don't think the New Jersey regulators wrote this bill. I think this was written elsewhere, and I think it was transported by a friendly top of the or agency hands into New Jersey labor apparatus. This is very, very sophisticated destruction. This is like improvised explosive devices. And what they've done is they've taken something that a buyer has to require in order to control their own liability and to control both to customers and to the people that they work with. And they're eliminating the buyer's ability to require that as a condition of actually accomplishing the work. So I believe it's false in its premise and grossly unwise in its requirement. And I have a hard time thinking it's going to survive, but it's only one prong.
But okay, let's move to B prong, because I know Kim has it in front of her, and this is where anybody who does, like, if you're a freelancer, you're a writer, you're self-employed, of course, listen, this affects you, but like, if you're a gig worker, listen to this B prong. You're going to immediately see you don't pass it. in no way will you ever pass it.
What I can do is read from this attorney analysis. This isn't my personal opinion. This is what this attorney wrote.
And again, guys, Kim is tied up in some other things, so she has to be careful what she says.
Against the federal government in an independent contractor lawsuit, so I got to watch it. But this is what the attorney wrote. One of the most objectionable provisions dealing with B-prong, the customer's residence or business location as a hiring entity's, quote, place of business. What he writes is that the proposed regulation, this I'm quoting him now, takes an extraordinarily expansive view of the second part of B-prong. It states that a hiring party's place of business not only includes locations where the enterprise has a physical plant or conducts an integral part of its business, but also includes locations outside of the putative employer's physical plant, where services performed by the individual are an essential component of, rather than ancillary to, the putative employer's business. He goes on to say, it's unclear what those words essential or ancillary mean in the context of the proposed regulation. And then a bit later, he gives the example of a contracted worker who's engaged by a carpet sales business to install carpet at a residence of the carpet customers, the company's customers. Each of the customer locations are also the hiring party's place of business if the carpet installation is an essential component. What the attorney writes, and this is a direct quote again, this view of the second part of the B-prong almost entirely eviscerates any chance for most independent contractors and companies using their services from establishing the worker's independent contractor status.
So I need to know this. So, I mean, the simple one was, so for you drivers out there, especially, like I'll say, what it is you can't do like Uber, Rideshare. I know it has Uber Eats too. So let's pick on Lyft. They just do Rideshare. Lyft, Rideshare. You can't do Lyft because their regular business is Rideshare. So if you're a Rideshare driver, you can't do Rideshare. You could be a plumber and go fix the toilets at the Lyft office, but you can't. And this is the old one. So why even deepen that? Because why even say outside of the building? What was the reason to even make this sound like that? Because they've already said if you do what we do, you can't be a contractor.
I would ask Mike that question.
There are a bunch of things going on in these questions. First of all, the B-prong originally had two parts, and the surviving part is the outside of all the places of business, and then there was an or clause, and I as well, and most people passed that, such as it's something like if they had their own place of business, then they weren't working for the main place of business of the buyer. And they've changed,
which is the C prong though.
No, that's an independently organized.
Oh, I thought it was that you're in a specialized trade. So if I'm a rideshare driver, I got my own business. But if I don't, and I'm only working for Uber or Lyft,
that is let me. This is really complicated because this gets into the history of the legislation. The ABC test is 87 years old or something like that. And it's been updated a couple of times in Massachusetts, most recently in 2004, and got a lot stricter. In 2004, they removed this second part, and I'm trying to find that report.
Instead of that, maybe I could reword the question. Is this just making sure, is this just like bulletproofing the building a second time to make sure there's no way that anybody can screw with the law? Is that what they're kind of doing in essence?
Yes. The word eviscerate is pretty strong in that attorney.
Yes. In Kim, in all due respect, the attorney and I, working separately, made the same mistake first time around. I want to go back to the sentence that deals with this. It's on page 27 if you're following along. The place of business where if the carpet's installed at the customer's residence, and then there's a gap, the service of the carpet installation was not an essential component of the carpet sales business. That is, the showroom where the carpet sales business displayed and sold carpet was its physical plant. The optional service of carpet installation was ancillary, there's that word that shouldn't be there, to, rather than an essential component of the putative employer's business of carpet sales, and therefore the residences of the carpet sales business's customers were not among the carpet sales business's place of business.
But I guarantee you any carpet business isn't going to say, hey, you can buy carpet from us and then we can hook you up with a contractor, because they do all that in one thing.
They actually do that in Massachusetts, although it's the same, it's the same thing. It's just billed as, a bunch of guys in a panel truck loading and unloading rolls of
right. But carpet. I mean, like, I think that they, just like a lot of other things, they take their cut of the installation portion too. So of course they're building that into the thing. That's why you see, hey, you can do a whole room for $99.
Right.
But it's really $700 when we add in the installation, like, come on.